So my name is Dae Bogan. I'm the head of third-party partnerships at the MLC. My role here is to establish relationships and partnerships with various sectors and entities in the music industry on behalf of the MLC for the purposes of supporting our publishers and songwriter members, as well as to develop relationships in the industry to further innovation and to further our mission as a nonprofit organization. Today, we're going to go over the copyright and mechanical licensing in the United States before the Music Modernization Act. I'm going to highlight the Music Modernization Act. I'm going to talk about the Mechanical Licensing Collective, what we do, who we are, as well as go over your eligibility as self-administered songwriters to join. And then lastly, we're going to talk about our music data organization worksheet, and then jump into our Q&A. Before we get started, I want to give you my social media handles, which is @DaeBoganMusic. You can find me on Twitter, you can find me on Instagram, you can find me on Facebook, you can connect with me on LinkedIn, so @DaeBoganMusic. All right, so this is the exciting part. I really enjoy talking about copyright. We're going to do a crash course on copyright and mechanical licensing in the United States before the Music Modernization Act. And the question is, what is copyright? Simply put, copyright is the legal right to control and exploit the original work of authorships for a limited duration. And it's important for songwriters to understand that there are two types of copyrights in the music industry. You have a copyright in the musical work, which is indicated by C in the circle, and a copyright in the sound recording, which is also symbolized by P in the circle, which stands for phonorecord. The traditional relationship between creators and music companies will highlight the difference between authorship and ownership in terms of copyright. It's really important as self-administered songwriters to understand the four buckets of entities associated with a copyright so that you understand where your royalties flow. As a songwriter, songwriters create musical works, including compositions and the arrangement of music and lyrics. Music publishers then control, monetize, and police that commercial exploitation of musical works. And this is the traditional framework. Those musical works are interpreted by performers in either vocal or instrumental performances and captured in sound recordings. And those sound recordings are controlled, monetized, and policed by record companies. So this is the traditional framework in the music industry where we have sort of four parties surrounding these two copyrights: your musical work copyright and the copyright in the sound recording, where these copyrights sit at the music publisher level and the record company level. So we're going to jump into a couple of case studies to highlight this framework that I just talked about. The first case study is I Will Always Love You. The songwriter was Dolly Parton, who wrote I Will Always Love You in 1982. The music publisher is Velvet Apple Music, registered the copyright in 1982 as well. The performer is Whitney Houston, and we know the popular version of I Will Always Love You from the 1992. And this performance, or this particular sound recording, was released through Arista Records in 1992. So this is just one example of the framework of the two types of copyrights: the musical work, which is written by the songwriter, in this case Dolly Parton, and the sound recording, which in this case was a recording of the performance of Whitney Houston. One more case study is All of Me. This song was written by John Stevens with Toby Gad. The publisher is John Legend Publishing, who co-owns the copyright in All of Me. The performer was also John Legend, who recorded All of Me. So far in these three of the four buckets I'm talking about, or three of the four parties, John Legend is a part of, which is important to understand in terms of being a DIY musician who writes songs and releases recordings. These are still three different parties to the work, even though it's represented by one individual and the entity that the individual owns. And then lastly, the sound recording was released through Good Music in August of 2013. The copyright in the musical work is held at the John Legend Publishing. The copyright in the sound recording was held at the Good Music on the master side. So now that we understand that there's two copyrights, one in the musical work and one in the sound recording, let's dive a little bit deeper into copyright law and what it means to be a copyright owner. A Copyright is a form of legal protection that ensures creators of original works of authorship a limited monopoly over the use and exploitation of the work once that work has been fixed in a tangible form. So what's important to call out is that a work must be original. So it can't be a version of someone else's, it can't be a remix of someone else's. In order for it to receive copyright protection as an original work, you need to actually come up with that work. And it needs to be fixed in a tangible form. So that could be, writing something down on sheet music. It could be writing something down on lyric paper. It could be recording in a DAW system and coming up with an audio file. Any tangible form to capture that work, that original work of authorship, is when you trigger copyright protection in the United States. The type of works that may be copyrighted are creations of the mind, which includes literary works, films, music, artistic works, architectural design. A copyrighted work is a type of intellectual property that can be sold, lent, licensed, gifted, or passed down by the copyright owner. The United States currently operates under the Copyright Act of 1976, and there have been several amendments since then, such as the Audio Home Recording Act of 1992, which established the digital audio recording technology royalties, the Digital Performance Right and Sound Recordings Act of 1995, which established a copyright protection for the digital public performance of sound recordings via cable, satellite, and internet services, the Digital Millennium Copyright Act of 1998, which established a limited liability or so-called safe harbor for internet services and websites. And then the Orangey Hatch Bob Goodlett Music Modernization Act of 2018, which established the blanket digital audio mechanical license for musical works. It also established a federal protection for pre-1972 recordings, and it codified a process by which music producers, mixers, and engineers may receive digital radio royalties. As a copyright owner, you need to know that the duration of your copyright protection for natural persons is the life of the author plus 70 years, while the duration for entities is 120 years after creation or 95 years after publication, whichever is earlier. So as a copyright owner, you get a set of rights, and these are your exclusive rights that is, again, protected by having a limited monopoly for the duration that we just discussed. These rights includes the reproduction right, which is the right to make copies or duplicates of your work, the distribution right, which is the right to make the work available to the public, the derivative right, which is the right to create new or alternate works based on the original work, such as modified versions, remixes, arrangements, or adaptations. The public performance right, which is the right to perform the work publicly or to cause performances of the work to be broadcast over terrestrial radio and television, or to be digitally transmitted via cable, satellite, or internet. And lastly, the public display right, which is the right to display the work or copies of the work publicly. So again, as a self-administered songwriter, you have two copyrights. You have your copyright in the musical work, you have a copyright in the sound recording. There are 4 buckets, songwriter, music publisher, performer, and record company that surrounds these copyrights. And as a copyright owner, you have these 5 rights that you can grant to others to utilize your works in any capacity. Those grants occur through licenses. So we're going to talk about the mechanical license, but there are other types of licenses. There's synchronization licenses, there's public performance licenses, there's print licenses. So those licenses create the grant of rights. A mechanical license is a license between a copyright owner and a user of musical work that grants that user the non-exclusive right to reproduce and distribute a musical work in a phonorecord, such as a CD, a vinyl, cassette, or digital audio file. One thing to note is that a mechanical license, in effect, gives a user permission to exercise 2 of your 5 exclusive rights. That's the right to reproduction and the right to distribute, or the reproduction right and distribution right. It does not grant a derivative work right, for example, a remix or a sample in a new work, nor does it grant public performance or public display. So a mechanical license is simply a conduit for granting another party the right to reproduce and distribute your work. The term mechanical stems from the way in which musical works were reproduced and distributed mechanically in piano rolls in the 1900s, early 1900s. So mechanical license is required to make physical phonorecords, to make digital phonorecords such as MP3s and WAV files, to record and release a cover song, to create ringtone versions of a song, to upload songs to interactive or on-demand streaming services such as Spotify, Apple, Amazon, Tidal, Deezer, to upload songs to digital download stores such as iTunes. And to obtain a mechanical license, a prospective user can either go to the copyright owner to negotiate a direct mechanical license or utilize the compulsory mechanical license process, which does not require direct negotiation with the copyright owner. The compulsory mechanical license is spelled out in Section 115 of the Copyright Act. That entails, one, filing a notice of intent to obtain a compulsory mechanical license to the copyright owner. That means if I want to create a cover song of someone else's work, I need to file this notice of intent to the copyright owner to let them know that I'm obtaining a compulsory mechanical license. I then need to calculate the royalties due based on the counting method and royalty rates associated with the type of mechanical exploitation. So for example, a digital download currently is 9.1 cents, whereas an interactive stream would be a different royalty rate, and that obviously comes through a number of services depending on the DSP. If I wanted to do a ringtone creation, there's going to be a set rate for that. So the rates are based on the type of usage. The compulsory license will enable you to make those copyright owners aware that you are in fact getting a mechanical license under the compulsory. Then you must account to and pay the copyright owner or an authorized representative for those royalties due under the license. Under Section 115, a user who is unable to locate the copyright owner in the public records of the Copyright Office could send the required notice of intent to the Copyright Office. But this would mean that that user is not liable to pay mechanical royalties until such time the copyright in the musical work had been registered with the U.S. Copyright Office. The public record looks just like this image here on the right side of your screen. So by registering a work, it becomes available in the Copyright Office public records. So that was before the MMA. Now some highlights from the MMA since it passed in 2018. So the Orrin B. Hatch Bob Goodlatte Music Modernization Act, or MMA for short, was signed into law on October 11, 2018. It is the most significant piece of copyright legislation in decades. The MMA is made up of 3 titles. Title I, which is the Musical Work Modernization Act, which we're going to dive into. Title II, which is the Classics Protection and Access Act, which established, again, a federal copyright protection for pre-1972 recordings. And then the Allocation for Music Producers Act, which codified a process for producers and engineers to receive royalties in regards related to the sound recording, digital audio performances. So Title I, which is the Musical Works Modernization Act, the U.S. Copyright Office named the Mechanical Licensing Collective as the designated MLC under Title I in July of 2019. Starting in January 2021, the MLC will issue and administer the new blanket digital audio mechanical license to eligible streaming and download services in the United States. We will collect the royalties due under these licenses from DSPs and pay songwriters, composers, lyricists, and music publishers. We will not charge a commission or administration fee, so 100% of the royalties earned and collected will flow to the payee. And the MLC will not issue mechanical licenses for cover songs, ringtones, or musical for physical phonorecords. The MLC is governed by a board of directors and 3 advisory committees. Our board of directors include 10 music publishers, 4 songwriters, and 3 non-voting members from the National Music Publishers Association, the Nashville Songwriters Association International, and the Digital Licensee Coordinator, which represents the DSPs. We have 3 advisory committees made up half of publishers and half of songwriters. That includes the Unclaimed Royalties Oversight Committee, the Dispute Resolution Committee, and the Operations Advisory Committee. So this diagram sort of illustrates the MLC's process in terms of standing up the organizations as well as our operational process. So I'm going to quickly go over each of these phases highlighted with these titles. So the first cut phase was last year, and that included the MLC number one, being designated, and then selecting the Harry Fox Agency as our vendor. In that process, we needed to start with a database of songs and copyright information from which we were going to build upon and administer the license, the digital blanket license. The next phase is our Connect to Collect phase, which is currently underway, which is promoting to self-administered songwriters and music publishers, making you aware that we exist, encouraging you to begin to prepare to join the MLC. And then once you join the MLC, the Play Your Part phase is accessing our portal, which will be rolling out in several weeks, accessing our portal and being able to register your songs, as well as searching the portal and the unmatched works once we start inputting unmatched data. Phase 4 is receiving DSP usage data as well as the royalties from digital services. This will come about in Q1 of next year. Once we actually begin licensing DSPs, we will start receiving the usage data and the royalties. We will then, in phase 5 here, match those usage data to the musical works that are in our database, as well as the musical works that you've registered new into the database, so that we can match the sound recording information to the musical works, then calculate the royalties that are due and pay out to the songwriters and the publishers. One thing to note is the database is a public database. So anyone will have access to the MLC portal to be able to search our database to see the songs. We will also have a public search for the unmatched works or the unmatched information in our system, so that publishers and songwriters who may have unmatched historical data can raise their hand and identify that information and provide us with the proper information to match and calculate and pay out those royalties. All right, so your eligibility for joining the MLC as a self-administered songwriter. Songwriters, composers, and lyricists are self-administered if you have retained the right to register your own musical works with the MLC and collect your own mechanical royalties directly or through a business manager, accountant, lawyer, or some other representative. So if you're a self-published songwriter, meaning you own the copyrights in your music, you are considered self-administered if you're still responsible for registering that music with the MLC. You're not considered self-administered if you've worked with a third party. So if you have signed your rights to register your musical works and to collect your mechanical royalties in the United States to a music publisher, so if you're in a publishing deal or an administrator, you will not need to become a member of the MLC. Your publisher and your administrator will handle your collection and registration on your behalf. If you work with a music publisher or an administrator in any capacity, please check with that music publisher or administrator before becoming a member of the MLC. So again, if you're a self-published songwriter, but you've hired some kind of publishing administration service to go and register your works and collect your royalties, then that administrator will be a member of the MLC and will be registering works on your behalf and receiving your mechanical royalties. If you have not hired an administrator, then you're still a self-administered. If you're in a publishing deal, then of course you're not a self-administered songwriter because you're not self-published. Now there are some cases, however, where if you have songs outside of your publishing deal that you self-administer, there is a possibility that you could be eligible to be a MLC member. You can reach out to our support. I'm going to have support information at the very end, but it's support@themlc.com. Reach out to our support to clarify if you are a self-administered songwriter. You can also talk to your publisher in regards to the songs that may fall out of your publishing deal to determine if, in fact, you do have administration rights on those songs. And there are some scenarios like that. So let me go into an example. This is Justin Michael Williams. He's a DIY music creator, do-it-yourself music creator, who wrote the song Here With Me. So Justin was a songwriter. This is going back to the framework that I talked about during the case study, the framework of the parties around the copyrights, right? Your songwriter, your publisher, a performer, and a record company. So in this case, Justin is a DIY music creator. He wrote the song, so he's a songwriter. He performed the song, so he's the performer. He owns the copyright in the musical work, and he owns the copyright in the sound recording. He's his own publisher and he's his own label. Now, compare that to John Legend from our case study, where John Legend did write the song All of Me. He does own a portion of the copyright in John Legend music. However, he hired BMG Rights Management to be the administrator of his portion of the copyright. Therefore, he is not a self-administered songwriter, and therefore he's not eligible to join the MLC as a self-administered songwriter for the song. Justin, again, wrote the song, performed the song, he's the publisher, and he's the administrator, so therefore he is a self-administered songwriter, and he is eligible to join the MLC. So I want to talk a little bit about the difference between the MLC and PROs, or performing rights organizations, when it comes to the royalty flow from DSPs. So you have your digital service provider in the United States, such as Spotify, Apple, Google, Amazon, Tidal. They pay out master royalties. Those royalties flow through the record companies and aggregators. So if you're an independent artist or a DIY musician and you use an aggregator like DistroKid or Muse or Symphonic Distribution or Create Music Group to upload your music to Spotify, then your royalties for the master flow right back from Spotify or Apple to the aggregator and then to you as the artist. If you're a independent artist who's signed to an independent record label, then similarly, your royalties would flow through your record company based on the terms of your contract, your agreement. But the DSP also pays out publishing royalties. And that includes performance royalties, which will flow through a performing rights organization like ASCAP, BMI, CSEC, GMR. And they pay mechanical royalties. Starting January of 2021, we will be licensing DSPs in the United States, and through those, the blanket license, and those mechanical royalties will begin to be paid out through April of 2021 from us, and that will flow through the Mechanical Licensing Collective. That flows to the self-administered songwriter. So here we have the artist receiving the master royalties, and we have the self-administered songwriter receiving the publishing royalties, which includes both performance royalties and mechanical royalties. But remember with the Justin's example, Justin was both the performer, or therefore the artist, and the self-administered songwriter. So Justin has 3 buckets of royalties: the master royalties, the performance royalties, and the mechanical royalties. Mechanical royalties is what flows through the MLC, but the performance royalties will flow through his PRO, and the master royalties will flow through the aggregator that he uses to upload his music to Spotify and Apple and Tidal and so forth. So playing your part. As a self-administered songwriter, it's very important to gear up to join the MLC, but also to address metadata issues that will help you register your works with MLC. We put out a tool, a helpful tool called the Music Data Organization Worksheet. This is for self-administered writers who have not registered their musical works with the organization like MLC before. We've created this simple, low-tech solution to help you sort your data and prepare to register your musical works with MLC. More experienced writers or writers with bigger catalogs may already have a tool in place to collect and capture their data. So you may not necessarily need this worksheet, but this worksheet is for writers who may not already be capturing your musical work data. So to get this form, you can download the form from the MLC's website by clicking on News and Resources, then Resources, click on Music Data Organization Worksheet, and then complete the web form to download the document. And what that looks like, you go here to News and Resources. I'll navigate to the Resources tab, click on Resources. And then we have the Music Data Organization Worksheet. Just fill out this form and you can download the worksheet, which looks like this. So here's the Music Data Organization Worksheet. The information that you need for this worksheet includes the writer names, the IPI numbers, which stands for Interested Party Identifiers. If you don't have an IPI number, that's totally fine. The shares for the writers, which should total up to no more than 100%. And then the publishers, if there are publishers, as well as the IPI numbers for the publishers, and then the shares. So this is what the split is for Justin for his Here With Me. Justin is with BMI, so we're able to see this information in the BMI's database and the ISWC code. Most of this information is optional, as you will see here. Again, the purpose of this organization worksheet is to try to capture as much information as possible about the work. So obviously you need the title, Here With Me, the ISWC code, if it exists. If this work has been registered already with a PRO, such as ASCAP, BMI, or CSAC, it may already have an ISWC code. Just for the purpose of example, I'm gonna show you what this looks like. So on BMI's website, I can search. If I was Justin, if I'm an independent artist, if I'm a self-administered songwriter, and I've already registered my songs with ASCAP or BMI or CSAC, then I can go and log in to my catalog, and you should be able to see the information such as your ISWC code, as well as the IPI number, Interested Party Identifier, for each of the writers on the work. So this is where this information is coming from. Now, if this work has never been registered before, then you will not have an ISWC code, but you may have an IPI number for the writers if the writers are a member of a PRO. So that's simply what we're asking here. Okay, so here we have the writer section. Here are each of the writers. Here are their IPI numbers. And then the income share data. So the income share, again, totals to a maximum of 100%. Here, for this particular work, we see that Justin Michael Williams is the writer, and Justin Michael Williams has his own publishing entity. So Justin has 25% of the mechanical income share under Justin Michael Williams Music. That's right here, Justin Michael Williams Music, 25%. Then we see Pig Factory, which is associated with John Humphrey, has 25%. So Pig Factory USA has 25%. And then we see Money Factory. Both Isaac and Thori are represented by Money Factory. So there's a total of 50%, 25 and 25. So 50%. So this is the income share. Now, if none of these writers had a publisher, then their name would appear in this income share section, right? So this is for the people or entities that have income share. In this case, Justin has his own publishing entity. So his publishing entity represents represents him. If he didn't have a publishing entity, if this was all blank, then it would simply just be Justin Michael Williams right? So in this case, he has his own entity. If you are a self-administered songwriter and you do not have a publishing entity, then your name will appear here as the writer, and then your name will appear here, and you would have your percentage here. At the bottom, we want to know the sound recording ISRC codes. So one way to try to find ISRC codes is to use the Sound Exchange ISRC search. So here is Sound Exchange ISRC search. You can search it and see if you can find the ISRC, which is in this column, of your recordings. You can also find that ISRC from your distributor or your record label, or if you log into your Sound Exchange account, if you've previously registered the works. So the goal here is to include all of the sound recordings that embodies this song. And again, this worksheet is simply for you to organize and capture your data. This worksheet will not be delivered to the MLC. This is not a registration worksheet. All right, so now I'm gonna ask my colleague Serona to join me on screen while we talk about the Q&A. She's going to moderate the Q&A, and I'm going to answer as many questions as we can in the time left. If you have any questions that we're unable to get to, please reach out to our support at mlc.com. You can also follow us on social media at mlc.us on Facebook, at mlc_us on Twitter and Instagram, and then find us on LinkedIn.
Okay, so I've got some questions for you, although I think I've tackled a lot of them.
Nice.
So there's a couple of different questions that have to do with services that people might be associated with, like Audium or CD Baby. So could you speak a little bit about, you know, some of those types of organizations and the role they play in here? People are wondering, you know, is CD Baby a legit publishing admin? And if they're registered with Audium, do they still need to sign up with us?
Sure. So again, we classify a self-administered songwriter as a songwriter who is still responsible for registering their songs and for collecting their royalties. So if you've hired an administrator, such as Audium or Songtrust or CD Baby Pro or TuneCore Music Publishing or Centric, and there's many, many, many others. If you hired any third party who's responsible for collecting royalties for you, for mechanical royalties, then you're not a self-administered songwriter for our purposes, because that company is therefore responsible for collecting mechanical royalties from the MLC on your behalf. That company would be a member of the MLC and registering your songs with us and collecting those royalties and accounting to you and paying to you in accordance with the terms of with their service. So for that purpose, you would not be a self-administered songwriter. I demonstrated that example with John Legend, where John Legend has John Legend Publishing, but has hired BMG Music Rights or BMG Rights Management to administer his share of all of me on his behalf. So John Legend would not be an eligible self-administered songwriter because there's a third party responsible for registering his share of those songs and collecting his royalties.
Thanks. That covered off a couple of questions. So someone was asking, does the MLC take the place of a music publisher?
No, the MLC is not a music publisher. The MLC is a music rights or music licensing organization. Our job is to license digital service providers, DSPs, to provide them with the blanket digital audio mechanical license, and to collect the royalties and pay music publishers and to pay self-administered songwriters who act as their own music publisher. So we work for publishers. We are not a publisher. Our job is to administer a license that has been developed under the Music Modernization Act, but we're not a publisher. And to that note, we also do not commission the royalties that we collect. So 100% of the royalties that we collect on your behalf will be paid to you without any kind of administration deduction.
Great. So somewhere along, I'm not sure what slide it was, you mentioned engineers, producers, and somebody thought, you know, those are involved with the neighboring rights side of the house, sort of sound exchange. So they weren't quite sure to explain a little bit more about the connection of those to what we're talking about here.
Well, Title II and Title III of the Music Modernization Act includes basically directives for these new grants of rights or these new types of rights. For example, Title II is we call like the Classics Act, has to do with pre-1972 sound recordings. We operate under Title I of the Music Modernization Act. So the MLC is born out of Title I of the Music Modernization Act. Title I is called the Musical Works Modernization Act. And then Title II and Title III has to do with other rights and other parts of the copyright. So Title II and Title III has to do with the copyright and the sound recording, which we talked about again, the P in the circle. Title III specifically codifies a process for paying producers, mixers, and engineers from the sound recording royalties for digital audio performances. And Title II simply provides pre-1972 sound recordings with copyright protection under which it didn't have before at a federal level.
Thanks. I think some folks would probably want you to clarify, they might have some songs that they self-administer and other songs that are administered. And so, you know, maybe making clear what they should and shouldn't do with respect to each of those kind of buckets of songs.
Yeah, so if you have songs that you administer, so let's say you're under, you know, you're actually in a publishing deal, and you know 50 of your 60 songs are represented by a publisher, but the other 10 are not. Then those 10, if you are the one responsible for registering those songs with ASCAP and BMI, for example, right? That's just an example that you have administration rights, and collecting the royalties from ASCAP and BMI as your own publisher, not the writer's share, but it's just a way to kind of look at this. Then you are self-administered. When it comes to the MLC, what we mean by self-administered means that you have the responsibility of registering your work and collecting the royalties. If you've given those responsibilities to a third party, such as your publisher or a publishing administrator, then you're not self-administered. You can still be self-administered for some songs and not self-administered for other songs. You need to speak with your publisher or your publishing administrator just to clarify that, to make sure that there isn't some responsibility for that entity to register your works with us, even if they don't own the copyright. Because there are scenarios where you might be in a publishing deal and that publisher owns the copyrights in a certain set of works, but then they may not own the copyright in some other sets of works, but still might administer those works on your behalf for you for a commission. In that case, you're still not self-administered. So owning the copyright is one indicator that because you're self-published, if you own the copyright. But once you hire or enter into a deal with a third party to administer those copyrights, whether they own it or not, means you're no longer self-administered. So I recommend, because these are very case-by-case basis, you're gonna have to speak with your publisher to get clarity on if that publisher is responsible for registering your songs with the MLC, even if they don't own the copyrights.
So someone was asking, once they fill out the worksheet that you showed them, then what happens? How does the data end up getting to the MLC?
So the purpose of the worksheet is a tool. It's simply a tool for songwriters who may not have already begun to collect and organize their data, so that when it's time to register works with the MLC, you have a place to go and find that information all in one place. That worksheet is not a registration tool. So you will not be sending it to the MLC. You will not be uploading it into the portal. You will not be emailing it to us. It's simply a tool that we created that's a free, easy to use, low tech way to start organizing your data. in the music industry, there are lots of music rights catalog management software companies that exist that some of you probably already use some of these companies to organize your metadata. We're just providing a free kind of low-tech tool to do the same thing. But this is not a registration form for your songs. It's not a way to register your new music. It's simply a way to organize the data about your music if you haven't already begun to do so, either with your own spreadsheets or with some software. Thanks.
This other question will also cover a couple of them. I think if you can make a quick distinction between, you still need to sign up with a PRO versus Sound Exchange versus us. I think people are not completely clear on whether they need to still register with all of them or now just us. That would be a helpful thing to explain again.
Yeah, sure. For that, I'm going to just quickly share my screen because I have that presentation I like to show. So again, in this scenario where we're talking about, sorry, thought we already went here. All right. All right, so remember in this scenario, Justin needs to receive his 3 buckets of royalties: his master royalties, his performance royalties, and his mechanical royalties. His master royalties has to do with the sound recording. That's completely outside of the publishing world, right? So he's an artist and he needs to receive that. If you're a singer, if you're a songwriter only, then you don't even need to look to this side because the master royalties are flowing to the artist. And if you're not the artist, that doesn't matter. But he needs to receive his performance royalties and mechanical royalties. Well, you see here, the performance royalties does not flow through the Mechanical Licensing Collective. It's not linked here. The performance royalties flow through performing rights organizations. They include, in the United States, ASCAP, BMI, CSAC, GMR. So if you're a member of ASCAP, BMI, CSAC, GMR, then that's where your performance royalties will flow through. The Mechanical Licensing Collective is only receiving mechanical royalties. The performance royalties are paid out as a result of your performance license that these organizations issue to the DSPs. The mechanical royalties are paid out, that will be paid out as a result of the blanket mechanical license that we issue to the DSPs. So these are 2 different buckets of royalties, performance and mechanical. And you have to be a member of the organizations through which these royalties flow in order to receive them.
Okay, great. That's really important. And that was so many of our questions were around that. There's some, another buckets of questions about for people who are already associated with HFA or have registered their information with HFA or MRI. And I think anything you can share about, the continued roles of HFA and MRI in the landscape, because they're not going to vanish, folks. So anything you could help share there would be great.
Great. Okay. Back to my screen. I want to highlight that, let's see, where were we? So I said earlier that a mechanical license is required for all of these things. Only the bullets in red is what the MLC will be licensing. These bullets, physical phonorecords, digital phonorecords, cover songs, ringtones. The MLC will not be licensing users who want to create ringtones. We will not be licensing artists who wants to do cover songs. We will not be licensing record labels or distributors who need a mechanical license for physical or digital phonorecords. The MLC is only providing a blanket digital audio mechanical license for interactive streaming and for digital downloads, limited and permanent downloads. That means all the other uses for mechanical licensing will still be administered through the types of companies that exist to do that work, such as Harry Fox, Music Reports, MediaNet. There's a number of companies that handle mechanical licensing. They also handle performance licensing, synchronization licensing, lyrics, and other types of licensing. The MLC, we are very limited to issuing a blanket license for a limited type of use, which is interactive use and digital downloads, either permanent or limited downloads. And we're limited to issuing those licenses to the type of services that will fall under a DSP. So we're not issuing licenses to record labels for mechanicals. Licensing is required for digital or physical phono records. We're not issuing licenses to independent music creators who want to do a cover song of their favorite artists, right? All that work still happens and will continue to happen under the types of companies that do that work today.
Great, that answered a lot of the questions. So let's see. So I'm scrolling through them all, folks. I'm trying to bundle them up to kind of cover them off with one answer. So also in the HFA question, some folks are asking, if they've got a lot of works, way more than the worksheet that you've shown could handle, like say hundreds, what's going to be the best approach for them getting their data cleaned up and to us?
Right. So you will be able to register your works with CWR, which is a music publishing standard way of registering works. You'll be able to do that in bulk. So if you're using a catalog management system, most standard catalog management systems allow you to export your works in a CWR, or they deliver, some of them already deliver the CWR on your behalf to organizations. So what you want to do is contact support@themlc.com to get clarity on your specific use case. There's a lot of different use cases, and I can't really cover them all. But if you're using a proprietary system or your own system of capturing that data, CWR is one way of doing that. There's also at HFA, where we will be receiving data, and we've continued to receive data, has a CSV file for their eSong bulk upload. So you want to get clarity on your particular process based on your unique needs by contacting support@mlc.com, and one of our MLC support representatives will be able to kind of guide you on the best way of registering your works. Everyone will be able to register their works inside the MLC portal by logging into the MLC portal, by going to registrations and to registering their works. But if you want to register your works in some kind of bulk format, there will be different options for that. And right now, I think the best is to contact our support and to let them explain based on your needs.
So I had a question also from I'm presuming a foreign-based songwriter. I know we've got some folks from Canada on with us. Sort of how is it supposed to work for them? Should they be joining us, or what can you tell them?
Sure. So our members also will include CMOs, collective management organizations from around the world. So if you are a songwriter in a territory and you're a member of a CMO that represents your mechanical rights, then that CMO will be collecting the royalties on your behalf from us, just like they do on the public performance royalty side as well from other organizations. So if you are a songwriter in a territory where you have not joined a CMO, then you still have your rights for the US. In that case, then you can join the MLC as a self-administered foreign songwriter. But if you've joined an organization in your territory and therefore have given up your administration rights for mechanical, then that organization will be representing you at the MLC in terms of their membership. I think we have room for one more question.
One more?
Yes.
Oh, so much pressure. Okay, one more. I don't even know which one to pick. I will just remind everybody that this webinar will be, you can access it on our website and on YouTube. I don't know if there's any one. I think we should just wrap it there. There's still a lot.
Okay, yeah, there's
flavors.
a ton of questions, I'm sure. The one kind of notes I want to leave you all with in terms of dates, we're targeting to open up membership for the MLC at the end of this month, end of October. So self-administered songwriters should get ready to join the MLC at the end of October. Then come January, we will begin issuing licenses to DSPs. And then we'll start receiving usage statements from that usage. And then April, we will begin distributions of royalties of April 2021. I'm happy to say that royalties from the MLC will be distributed on a monthly basis. So every month, if you've earned royalties every month, then you'll be paid out on a monthly basis. And again, we do not have a commission. So 100% of the royalties you earn will be paid out to you. I just want to reiterate, if you have questions still, go ahead and send that to support@mlc.com. If you want to connect with me in general, find me at Dae Bogan Music, DaeBoganMusic. You can also connect with me on LinkedIn. Thank you everyone for tuning in. I appreciate it.
Bye everyone.